Please, Your Lordship. Lordship, I beg to mention item number 1, Your Lordship. Lordship, I pray this matter become up first week of March.
It's a very old matter.
Old matter. It required to be. In 1 or 2 days we can just finish it up continuously.
We should make it. Otherwise,
Yes. I think some difficulties he expressed.
you're for respondent?
Respondents.
All respondents? How many respondents?
Only bank.
State respondents there. You're for?
The bank.
It is mainly with the bank.
On premier by Mr. Learner Counsel for the respondent bank seeking accommodation on ground of personal difficulty. The same not be objected to by the petitioner. That is adjourned. This is the same after 2 weeks.
Can it be first week of the March, I think, Lordship? We can finish it up this minute.
Excuse me.
6, 7 like that, Your Lordship. If no inconvenience, Your Lordship.
Takang tarik. One, 2, 3 weeks.
Yes. Much of it.
May I please, Your Lordship? Your Lordship, I beg to mention item number 4, 5 and 6. They are connected matters.
Yes.
Your Lordship, we pray for some accommodation, Your Lordship. And as for item number 5, here the respondent has passed away, Your Lordship.
Passed away. Pass away.
Yes, Your Lordship.
What is the stage?
Section of that, my lord? For the time being, maybe.
What is the stage of the trial?
So, under evidence, Your Lordship.
So how many witnesses have been examined? How many are left?
Here, I think so. Two witnesses has been examined, Your Lordship.
Oh, only 2.
Yes, Your Lordship.
Yes, Dr. Muzika, how many witnesses are there?
Because these are common trial, my lord. 3, 4, 5, and 6.
Yes, it appears so.
My lord. So two witnesses, most probably, my lord. And either way, the matter, if they cooperate with the matter, may be disposed of either granting or allowing. This is pending for quite some time.
Exactly. We should hear this matter, you see. It's a question of this is a application for cancellation of bail.
My lord. Not cancellation of bail, we have come again on appeal, my lord.
Oh, okay. No, it's not an appeal. It's a criminal petition.
My lord.
It should be 482.
482. So primarily, because there is no provision of a bail appeal, my lord, under CRPC.
Okay.
So only we have to come under 482. I have supporting judgments on that, my lord.
Yeah, of course. 482 is inherent power, can be exercised at certain, under certain
Because
circumstances.
our case is, my lord, on the face of 37 in DPS Act, my lord, the bail has been granted to them, all the accused persons, my lord. On the one hand, court has framed the charges on prima facie being satisfied that there is a material, my lord. And on the other hand, granting bail saying that there is no prima facie case.
But we have to look at the progress of the trial.
My lord.
If the trial has progressed significantly, even at the stage of recording of evidence,
Of course, my lord.
then what is the point?
But the matter is heard either way, my lord. But they're seeking.
And now you say that one of the accused has, then you have to.
We will procure the death certificate on the as soon as we
the
receive
trial
the
itself.
bail.
my lord.
So this is from this 3, 4, 5, 3 to 7.
3 to 7.
On payment with the parties, let's just matter up to 2 weeks. Let's finish this off. This court has been, this matter has been hanging for so many dates.
But either way, it is disposed of, my lord.
Has to be.
I'll oblige, Lordship.
From supplementary list, item number 1.
Number 1 and 2 are connected. If Lordship kindly takes up 2, my lord. Item number 1 and 2 are connected. Number 2. Well, this is a bail application, my lord, for anticipatory bail.
Yes.
Well, here what happened, my lord, at the beginning, I must submit, my lord, earlier a bail application was filed in connection with this case, my lord, before this honorable court, my lord. And this honorable court was pleased to grant interim bail, my lord. I'll just place the order. That has not been annexed.
Same case.
It is saved. And then subsequently it was withdrawn, my lord, with liberty to file afresh. Then, my lord, Lordship kindly turns to page 92, my lord, of my petition, the last page.
Yes.
By this order 10/12/24, the application was withdrawn, my lord. With the liberty to, well, here what happened, well, because of some difficulty, he could not appear before the IO at that point of time, my lord, because he is a resident of Jaipur. So it was withdrawn, my lord, and now we have come back, my lord, after about 2 months.
Anticipatory bail.
Anticipatory bail. My lord, and
Well,
what is
see,
what
now
is important, my lord?
If you take that period of 2 months,
My lord.
where's the question of apprehension then?
But the apprehension is still there, my lord. Why I am submitting, my lord? There is in the same cause of action, my lord, in the same series of action, my lord, 3 FIRs has been filed against the accused person, my lord. My lord, in one of the FIRs that was filed before,
This is with regard to this bonded
warehouse, my lord.
case.
In one of the matters, your lordship granted bail, my lord, and we are complying with the bail conditions. Lordship kindly turns to page 58, my lord.
Yes.
My lord, this was in connection with Tura case, my lord. One FIR is filed against the same accused person in the same series, but it was running a bonded warehouse. Lordship was granted bail, interim bail, and we are complying with that, my lord. But my case is, my lord, all the sections are within 7 years, my lord. Even otherwise, also the Arnesh Kumar will apply, my lord.
Yes.
I'll just take your lordship to the FIR, my lord, and this.
Have you received any relevant notice?
We have not received, my lord. But my lord, the police is hyperactive in a case of cheating. My lord, I'll just read the FIR, my lord. Your lordship kindly see the nature of offence, even the allegations, my lord. I'll just take your lordship to the FIR, my lord. At page 27, my lord, the first FIR.
Yes.
Page 27. I'll just read, my lord. Superintendent of Police, Rivers District, dated 9th July 24. Now, with the reference to the subject cited above, I, Srimati Suchona C.H. Sangma, the proprietor of Suchona Bonded Warehouse, 9th Mile, so-and-so, had appointed Sri Gopal Krishna God, so-and-so, permanent address, so-and-so, as my manager to look after the affairs of the warehouse under his full control since February 16 till 11 June 2024. However, in my surprise visit in the warehouse on 12 June 24, I have found most of lost of misappropriate and also mismanagement of the warehouse and other official documents, also suspicious and unknown bank transactions. So I called my chartered accountant for the audit. There we found minus in stocks, and comparing with excise register, the stock were huge difference also. Some of huge amount were misused by a portrait person and also forged my signature to access the bank and other official documents. Thereafter, in this ongoing audit, his son Rahul came to warehouse office and stolen up the laptop and file and the data where all the information of the warehouse were available, and also I have given them sufficient time to clear all the doubts of stock, sales, purchased and bank transaction, but they failed to do so. Mrs. Sulochana Bonded Warehouse have vehicle to transport the goods to retailer. Among all the vehicles, one vehicle is missing, registration number so and so. Now last para, my lord. The above act of Sri Gopal Krishna Gaur amount of cheating, misappropriation, fraud, forgery and stealing, and also cheating a person belonging to a scheduled tribe. To the best of my knowledge and understanding. Now my lord, this is important, my lord. Sri Gopal Krishna Gaur is fully liable and answerable to pay the liabilities and dues against my bond. So my lord, the sum and substance is that she is alleging that Gopal Krishna Gaur is liable to pay the dues, liabilities and dues. But in my humble submission, the conclusion of the FIR itself is civil in nature, my lord. Now to cover this story, my lord, they make out 100 types of stories, 100 types of things, but the sum and substance of the FIR is that Gopal Krishna Gaur, if any, is liable to pay some amount to the complainant. And the case has been registered, my lord, kindly see on the next page 29, my lord. At serial number 8, my lord, the sections are invoked, my lord. Now 381 is extendable up to 7 years, my lord. 408 is extendable up to 7 years, my lord. 120B is inconsequential for the moment. 417 is only 1 year, my lord. 418 is up to 7 years. 420 is also up to 7 years, my lord. So all these sections are covered by the otherwise also Arnish Kumar's judgment, my lord. So, my lord, in these circumstances, my lord, in my humble submission, arrest may not be is not required, my lord, and the police has to follow the provisions of
Exactly.
of the law. my
Now,
lord.
if you insist to say that all the
Sections, my lord.
sections are punishment are within 7 years or 7 years,
My lord,
it's incumbent upon the police to issue notice
my lord,
material to section 41A.
my lord.
Now,
It's 35 now. Section 35 of the NS.
right, DNSS.
My lord,
Now, if that is not done, then it's the question of apprehension. If the police comes looking for you, they are first to issue the notice. It is mandatory.
my lord.
And if they, perchance, they arrest you without issuance of the notice, then you have a case for bail or otherwise.
My lord,
But
what do
now
you-
we are, you see, when we speak of anticipatory bail,
my lord.
in my opinion, it is only when you anticipate, being arrested.
My lord,
Now,
there
how
is
would you anticipate being arrested? Because there is a process of law in place.
well, that threat is there, my lord, and
if you-
that's why in the other case, Tura case, we approached this honorable court, my lord.
No, that is true. So, but now we are looking at, since you have pointed out the relevant provision,
My lord. My lord, if lordship protects us with that observation that without 41A notice or section 35 notice, there will be no arrest, my lord.
Mr. Khan, you seek instructions.
Lordship, the order which my friend is mentioning, Your Lordship, again is that the complainant had filed a cancellation of bail. That is coming up on 24th
In this court.
February, Lordship, 24/2. And slight background is required, Your Lordship. What has happened in this case, when this court granted an anticipatory bail ad interim, and we were strongly opposing it for the simple reason that he was avoiding 41A notice. And that particular day, Lordship, we had brought the IO's report. He was not complying with 41A. In spite of the fact interim was granted, he never went to the police station.
If he has not complied with 41A.
41A was
Or
not
35 for that
complied,
matter.
and then in spite of the fact 41A, this particular provision was, my friend was not the counsel then, so that particular point was not brought to the knowledge, but court said, okay, we'll give a 1 week's time. And in the 41 was issued, and then we 1 week's time, interim was granted, still he chose not to go.
No, but you see, if 41A is not complied with, is there a report?
No, Lordship, I'm talking about the first level of
Yeah,
litigation.
even then, has subsequently
So
has,
at
has the
this
IO
stage-
filed a report
No,
that
Lordship, yes, he had filed a report. We have brought to the knowledge of the court.
that he is
So at-
that
at
he-
the- yes.
okay, that
So
he
this
is that he is to be arrested.
Yeah, absolutely. That was a situation, in spite of the fact interim was granted also. So at this stage, Lordship, we'll just pray because there's too much of overlapping fact and cancellation of bail happening. They've all got a checkered history last 7 months. So we don't, as Lordship rightly said, kindly allow us to just file a report at least. At least a report. And as Lordship rightly said, if it's the issue of 41 is there is no question of apprehension.
You file a report then.
We'll just file a report.
2 days.
To the Khangai?
Today's 12th, my lord.
Come back by 19th.
It is coming on
24th. Lordship, let it be on 25th because 24th is coming. We have to get it from Tura.
Status report is coming on
24th.
Oh, this is Khanapara. This case is Khanapara.
Hard, Mr. Doctor and Procedural Senior Counsel, along with Miss. You are also there? Yes. I looked over. The
Yes. Lordship, for respondent number 2 in this case, I'll appear, Lordship. I'll take the Lordship. Lordship knows all my cases are pending for Suchana's cases. For this case, Lordship, I'll place my wakalatnama during.
No notice has been issued.
Lordship, as a respondent number 2, Lordship, it is there,
he has
Lordship.
he has not even contemplated issuing notice to you, but you have said, no, give it to me. Okay, we'll note it down. Was submitted that an FIR dated
9/7/24.
9/7/2024 was lodged by the respondent number 2 herein.
Well, in fact, there are two. There is a supplementary FIR also. That is at page 31. Follow-up FIR, my lord, of the same FIR. At page 31, my lord. So, Lordship may say FIR 9/7 and 9/7 and 17/7.
Hadin Gatuka 9/7/2024, followed by a supplementary FIR dated
17/7.
17/7.
Yes, my lord.
17/7/2024, lodged by the respondent number 2 herein, with specific allegations against the petitioner herein and his son, namely Shri Rahul.
Gopal is the father, my lord. Rahul is son.
Who has come before this court?
Both, my lord. The two applications, my lord.
Oh, against this. Where is the averment that you have come, with this application for both?
But there are two separate applications, item number 1 and item number 2, my lord.
Okay. So we'll pass a common order.
Common order.
FIR same.
Same FIR.
It is the submission of the learned senior counsel that a charge sheet has been filed.
Charge sheet is not filed.
Because
No.
So that's why we require a status report.
charge sheet is not been filed. Investigation not
Not yet, Lordship. That's why they've come for anticipatory review.
2024 matter.
July 24. 7 months.
What are you doing?
So that's what, at least to find. We need a status report as to what has happened.
Conduct of the IO has to be examined.
Yes, absolutely, Lord. As per the instruction, His Lordship, Ayu had gone all the way till Rajasthan to locate him, couldn't trace him.
You file your
See, that's for Lordship. At this stage,
CD.
we'll file a status report, Lordship. What is that, please?
Rajasthan.
The FIR being registered as Khanapara PS case number 25 under bracket 7 2024 under section I22 section 331 would reveal that all the sections carries penalty of 7 years or so if 7 years or so, and as such it is incumbent upon the IO to have firstly issued notice under section 35 of the
35 subsection 3.
35 under bracket 3 of the PNSS. However, no such notice has been received by the petitioners. I have to pay you a common order. In any case, since the petitioners are apprehending imminent arrest, this court has been approached with a prayer for grant of anticipatory bail, if not immediately granted, prayer for interim bail is made herein. Mr. K. Khan, then PP, has accepted notice on behalf of the state respondent, and Ms. P. Vatsyaji has also accepted notice on behalf of respondent number 2 and has sought time to file the necessary powers and to seek instructions in this matter. This court, on perusal of the FIR and the papers submitted herein, is in agreement with the assumption of the learned PP that the IO be directed to file the copy of the CD and the latest status report. Without going to the merits of the case, the IO is therefore directed to file the prosecution is therefore directed to produce the copy of the CD with the latest status report of the IO. At this stage, considering the facts and circumstances as has been revealed herein, this court is not inclined to issue any interim order in this matter. This matter on. Why 25th?
My lord, only one submission, my lord. Your lordship permits us to appear before the IO on 17th, my lord, and he should not be arrested on that time, my lord.
Why?
He'll appear before the IO on 17th, my lord.
If he appears, then he appears.
But there is apprehension of arrest, my lord, if he appears. That's the only thing, my lord.
See, he will not be arrested because of this 7 years factor.
Lordship is correct, yes.
Secondly, the relevant notice has not been issued.
But I've been told, my lord.
If it has been issued, the next, as we have said, the next step would be the report before the concerned magistrate to have him arrested. Then
Well, what I've been instructed, my lord, the police went all the way to Jaipur, my lord, to arrest him.
Not on for this particular matter, for some other
Some
matter.
other matter, yes.
Maybe for that Tura case. whatever.
That is coming up on 24, Your Lordship. It's overlapping, so we don't know exactly what.
Only
My
on
friend is here.
17th, your lordship protects us, my lord. The whole purpose
Because you see,
of investigation is that we cooperate, my lord. 17th, I am undertaking to appear before the IO, my lord.
this court is bound to take judicial notice of certain related matters concerning the same petitioner. Certain things have yet to be clarified as to his conduct, as to why he failed to appear before the IO, and so on and so forth.
Well, only 1 or 2 documents, my lord. I'll just place before your lordship, my lord. Only to persuade your lordship. My lordship, kindly see 1 or 2 documents, my lord. The same complainant has given no liability certificate to me, my lord.
Well, that's on a merit.
Now 21, there is a severance of relationship, all business relationship, my lord. She gives an affidavit saying that the petitioners have no further liability towards her.
That is, I think, a similar situation is also in the other case,
Well,
where such things have been.
So, Lordship,
Later it transpired that
only for 70, the lordship protect us, my lord. We will appear before the IO, my lord. Whatever investigation,
have you
whatever.
been called by the IO on 17?
Well, we have not been called, my lord, but our only apprehension is that if we go, my lord, we will
Why
be.
17? What's so special about 17?
But it's any date, my lord. Lordship permits us to appear before the IO before the next date of hearing, my lord. We'll appear on that day as per the convenience of the IO, my lord. The purpose of arrest is not to punish, my lord.
No, it's not to punish. No, definitely.
But there's a immediate threat. There's immediate threat of his arrest, my lord. Well, kindly protect it only to that extent, my lord.
This to us. To us, no?
This is 12th, my lord.
Otherwise, Lordship will try to get the status report
Where is he
earlier.
now?
He's in Jaipur, my lord.
Jaipur.
He'll come and appear any day before the next date of hearing, my lord.
Otherwise, Lordship can prepone that we'll try to get the status report as early as possible, maybe by 19 then.
And you file your status report by Friday.
This Friday?
Yes.
Okay. Okay.
14th. We'll see Friday.
Okay.
Yes, ma'am. List this matter on 14. If any interim order is to begin, we'll see it on Friday.
Status report.
Same order, item number 1 and 2.
I think a common order will be passed.
Item number 3.
Deeply.
May I please, Your Lordship? Lordship, I have come before this honorable court several times, and the last, Your Lordship, this honorable court was pleased to reject the bail on 17/5/2024, 9 months back. Your Lordship, at that point of time, the case status was same as of now. That time also the charges was yet to be framed, and even now the charges has not been framed.
Not yet framed.
Not been framed, and the accused has been languishing in jail for almost 20 months. 21 months.
NDPS?
NDPS, Your Lordship. Your Lordship, on the last rejection of the bail, Your Lordship, in this case, Your Lordship, there is no, it is an immediate fact that contraband was recovered from some jungle.
Oh, that
Yes.
that boy.
Yes, Your Lordship. And Your Lordship,
You are the driver or you are a passenger?
no, my brother was, that time he was driving local taxi. And since it was night time, 2 passengers they hired, so I accompanied. That driver, this is not for the driver, he was the driver since he requested me because it was night time. So as a brother, I just accompanied him for this particular accused, this bail is application. So now, Your Lordship, on the last occasion also, considering only that CDR, Your Lordship.
See, the only change of circumstances.
Change of circumstances.
Only change of circumstances that can be
taken
availed
into
of,
consideration.
that can be availed of as of now.
Yes, yes.
Is with regard to prolonged trial. Otherwise,
Yes, that is. I have enclosed certain citation, Your Lordship. That is, I'll just read, Your Lordship. One thing I wanted to point.
Charges have not been framed.
Not been framed.
But when was the charge sheet filed?
Charge sheet was filed in the month of December 2023.
Yes, Mr. Dr. Muzika, what is this?
But my lord, the matter comes on Friday, my lord. I'll have
It
it.
takes so long filing of charge sheet.
But
It means you don't have a case.
the trial counsel is some. I'll just have it. Friday, my lord, the matter comes.
Friday, this Friday, tomorrow.
Day after tomorrow.
One case name Friday, right? I'm going on Monday. Monday. Do it. But he just you order. We'll fix it on Monday.
You, my lord, Monday I will be out of station. So let it come on then 24th yours.
24th.
Heard Mr. Respondent, Land Counsel for the petitioner who has submitted that this application, this is the
Fourth bail application.
that this is a fourth bail application preferred by the petitioner. Fourth before this court or before
This court.
before this court. Fourth bail application before this court preferred by the petitioner. The Land Counsel has specifically contended that the petitioner is innocent and is not at all involved as far as the alleged offence is concerned. This is concerned. So, secondly, the progress of the trial has been inordinately delayed, inasmuch as the charge sheet was filed when
2011-2023.
on 2011-2023. Until date, the Learned Trial Court has yet to frame charges or consider, has yet failed to consider whether charges are to be framed or not. On these two twin grounds, the Land Council has submitted that the petitioner will be allowed to be enlarged on bail. Dr. N. Musical and DSGI, along with Ms. has submitted that he may be given some time to seek specific instruction as far as the progress of the case is concerned. On pre-made as agreed to by the parties, this is matter on 24 for further hearing.
Charges has not been framed. Charges has not been framed.
Not been considered whether they are, see, first you consider whether they are to be framed.
That has consideration has been done. Charges has not been framed.
Oh,
Yes.
charges considered in what sense?
The court has said that we will frame the charges.
Oh, the court has, okay.
But charges has not been framed.
So, charges have yet to be framed.
Yes. My lord, second case also, item number 4 also, that is the second bail application for that.
Same.
Same person. Same offense.
But that is second bail application for him.
Second. All, everything remains same.
Yes.
Deeply.
Daily list, item number 1.
What?
Item number 2.
May it please, Lordship.
Lordship, on the joint request of both the parties, I pray if this matter may be taken after 2 weeks.
The private respondents, Lordship, the petitioner and the private respondents, they are making a joint prayer.
Who's for private respondent?
Conducting counsel KP Bhattacharjee, sir.
I have no objection, Lordship.
On prayer made by the petitioner, this is matter up to 3 weeks.
Obliged, Lordship.
Highly obliged.
Item number 8.
हजुर आइटम नंबर 2 बोला थियो वो बस ठीक है
Chief, try. Yang trouble chief kan asal.
Wait, please, your lordships. Lordships, I beg to make a mention of item 11.
See, this matter has been adjourned for far
Lordships.
too often. I have forgotten about the
No objections.
subject matter. The state has been heard in this matter.
Not yet, Lordship.
Lordships, the hearing has been concluded, Lordship.
Lordship, I think so.
Arguments have been advanced.
Lordship, I think so. We have to.
That's what I'm saying. Now I've forgotten what it's all about. How long?
Lordships, 2 weeks.
On pre-mid, Mr. General Counsel for the respondent, Contempt has submitted that has prayed for accommodation on the ground that the Narad Senior Counsel, Mr. Kepol, who is conducting the matter, is in bereavement. The same not be objected to by the petitioner. Matter is adjourned. List is here after 2 weeks.
Highly obliged, Lordships. Wait, please, your lordships. Your lordships, I beg to mention item number 12. Your lordship, the conducting counsel is not keeping well. Your lordships, I pray that the matter may come up after 2 weeks.
No
You are
objection.
I am for the petitioner, your lordship.
Petitioner or appellant?
Appellant.
Appellant, your lordship, sorry.
On pre-made by the appellant, not objected to by respondent. List this matter to 3 weeks.
Obliged, your lordship.
Daily list, item number 1.
May I please, your lordship? Your lordship, I'm seeking some more time to file a rejoinder. So kindly 3 weeks, your lordship.
Miss General Counsel for the petitioner has sought for some more time to file the rejoinder to the counter affidavit filed by the respondent. Pray aloud. This is matter of the 3 weeks.
Highly obliged, your lordship. Item number 4.
May it please your lordship. Lordship, this is a state appeal, your lordship.
Yes.
May it please your Lordship. Lordship, in this case, your Lordship, the respondent writ petitioner, your Lordship, they file a writ petition claiming for themselves to be covered by the old pension rules, your Lordship. So that relief has been allowed by the learned special judge, your Lordship, or by the learned single judge, your Lordship. Against that, your Lordship, we have filed this appeal. Lordship, the impugned order is at page 245.
What is the factual background?
The factual, your Lordship, Lordship kindly come to page 65. Lordship, this is the advertisement, your Lordship.
Page 65.
Lordship, page 65, your Lordship. This is the advertisement dated 27 September 2007, your Lordship. They applied, your Lordship, and they were appointed under as GDA, your Lordship, under 3F rule of 1972, your Lordship.
3F.
Lordship. And their appointment, your Lordship, will find at page
3F applications are always a stopgap arrangement.
Lordship, yes. Lordship, yes. If Lordship, I'll read the advertisement. Kindly come to page 65, your Lordship. Application in prescribed standard form are invited from eligible candidates and residents of Meghalaya for temporary appointment as junior divisional account under 3F of the MPSC Limitation of Function Rules 1972, your Lordship, until regular recruitment through MPSC and appointment is made in accordance with the service rule. Lordship, I would highlight that until regular recruitment through MPSC and appointment is made in accordance with the service rule. The posts are so and so, your Lordship.
Yes.
So, your Lordship, they took part in this temporary selection process, your Lordship, and they were appointed, your Lordship, in the year 2008-2009. Lordship, kindly come to page 66. Lordship, this is the order of appointment, your Lordship.
Page 66.
Lordship, yes. This is the order of appointment. Since this is a temporary appointment, your Lordship, then they were regularized by the by the government, your Lordship, on on 2nd March 2020, your Lordship. Lordship will find that at page 77. Lordship, it has been regularized by the Meghalaya State Public Service Commission, your Lordship.
Yes.
Lordship, this is the letter from the Secretary Meghalaya Public Service Commission to the Undersecretary Personal and Administrative Reform B Department, your Lordship, saying that the Commission approval for regularization to the 39 divisional accountant appointed under Regulation 3F of the MPSC Limitation of Function 1972. Then Lordship will kindly come to the next page, that is page 78, your Lordship. That is the order of the government, your Lordship, issued by the Finance Establishment Department, your Lordship. Lordship, this letter, Lordship, kindly come to page 79. Lordship, clause 4 of that letter. Clause 4 of that letter.
Yes.
The 38 numbers of junior divisional accountant shall be governed by the new defined contribution pension scheme by finance so and so, your Lordship. So, being aggrieved by this clause 4, your Lordship, a writ petition has been filed, your Lordship. Their case is that, Your Lordship. Lordship, their case, Your Lordship, Lordship will find, kindly come to page 52.
52?
Not 52, Your Lordship. No. Not 52, Your Lordship, I'm sorry. I got repetition. Just page 52, Your Lordship, at page 10. The case of the respondent writ petition start from page 52 at paragraph 10 of the writ petition. That is the writ petition, Your Lordship.
Yes.
Lordship, their contention is done, Your Lordship, since they were appointed. Lordship, before I come to that, Your Lordship, the new pension scheme, Your Lordship, came into effect with effect from 1st April 2010, Your Lordship. So they filed the writ petition, Your Lordship, contending that since they were appointed prior to that cut-off date of the new pension scheme, they should be governed by the old pension rules, Your Lordship. That is the Meghalaya Pension Rule 1983, Your Lordship. Lordship, our case is done since the writ petitioner respondent, they have been. It is true that they were appointed in the year 2008-2009, but they were regularized, Your Lordship, by the Public Service Commission, Your Lordship, and by the government, Your Lordship, in the year 2020. And in that view of the matter, Your Lordship, they do not come within the purview of the old pension scheme, Your Lordship. They should be governed by the new pension rules, Your Lordship. But our case, Your Lordship, has been negated by the learned single judge, Your Lordship. Lordship, kindly come to page 182. Of the writ appeal, Your Lordship. 182, Your Lordship. That is the guidelines for implementation of the new defined contribution pension scheme. Whether Your Lordship is with me?
Yes.
At page 182, Your Lordship. Lordship, kindly have a look at 3.1.
Yes.
Lordship, there is no dispute with regard to the cut-off date of the new pension scheme, Your Lordship, 1st April 2010. Lordship, kindly see 3.1. Yes. The scheme shall be applicable to all new entrants joining state government service on regular basis against sanctioned vacant posts on or after 1st April 2010. It shall also be applicable to government, Your Lordship, to government employees whose services will be regularized against regular posts on after 1/4/2010, which with the benefit of prospective date. So our case, Your Lordship, the case of the state is that, Your Lordship, since the writ petition respondent have been regularized in the year 2020, Your Lordship, this clause 3.1 will be applicable to them, Your Lordship. So they are not, they will not come within the purview of the old pension scheme. They should come under the new pension scheme. That is our case, Your Lordship.
Where is the observation of the learned single judge?
The observation of the learned single judge, Your Lordship, will find an Lordship will find at page At page 256, Your Lordship, paragraph 8. At this juncture,
Yes, what does it say?
at this juncture, it would be expedient to examine the letter of regularization dated 19/2/21 and its entire purport thereof. It is noted in this letter before the clauses condition of the regularization, including the impugned clause, are contained, wherein it was stipulated that the new pension scheme would be applicable. An umbrella paragraph had been inserted which read as follows. The regularization is, however, subject to the following condition as stipulated by personnel and AR department number so and so. It is interesting, Your Lordship, I'll come to that, Your Lordship. It is interesting to note that in this,
you're reading?
Lordship, I'm reading at page 256 at paragraph 8 of the impugned judgment. 258, Your Lordship. Or 256, Your Lordship, sorry. Paragraph 8, Your Lordship.
Yes.
Lordship has gotten.
Yes. Please continue.
We read as follows. The regularization is, however, subject to the following condition as stipulated by personnel and ARB department letter number so and so, dated so and so. It is interesting to note that in letter dated so and so, which deal with matters relating to ad hoc appointment, in the second condition given therein, the regularization, it has been provided as follows. The period under 3F appointment, ad hoc appointment of each incumbent would be taken into consideration for the purpose of leave, pay, increment, pension, etc. as per existing provision provided under FR 28A. The inclusion of this paragraph in the letter dated is clearly at odds with clause 4 of the letter, inasmuch as the letter dated so and so allowed for the period of ad hoc appointment to be taken into account for the purpose of pension also. The guidelines for implementation of the new pension scheme at clause 3.1 read as follows. The scheme shall be applicable to all new entrants joining the state government service on regular basis against sanction posts, vacant posts on or after 1st April 2009. It shall also be applicable to all government employees whose services will be regularized against regular posts on or after 1/4/2010 with the benefit of prospective date. No doubt this guideline has to be taken into consideration while determining the entitlement of employees based on the date of regularization. However, as noted earlier, the letter dated so and so regularizing the services of the pension on the one hand, while applying the condition as contained in the letter dated so and so, whereby the period of 3F appointment was to be taken into consideration for the purpose of pension. In the same letter itself had inserted the impugned clause denying the pension the benefit allowed by the letter dated so and so. This contradiction, which is present on the face of the record, in the opinion of this court, cannot be reconciled harmoniously, coupled with the fact that the guidelines for implementation of the new pension scheme are not statutory in nature. In this view of the matter, therefore, the petitioner, for the period of 3F appointment, having been allowed all other benefit toward reckoning their service with regard to leave, pay, and increment as per FR 28, this court, by giving a liberal interpretation to the letter dated so and so, see no reason to deny the petitioner the added benefit of being governed by the old pension scheme of 1983 also. As such, consequently, the impugned letters which contradict the benefit allowed to the letter 70 is hereby set aside, and the respondent are directed to place the petitioner under the old pension scheme, namely the Meghalaya Civil Service 1983. Lordship, kindly come back to page 77. Page page 78, Your Lordship. The relevant page, page 79, Your Lordship. Page 79, Your Lordship. That is the letter which has been reflected in that impugned letter 19/2/2021. Lordship, kindly come. The regularization is, however, subject to the following condition as stipulated by personal so-and-so, dated so-and-so. The effective date of regularization of service will be from the date of issue of government notification. Past service under Regulation 3F shall not be counted for seniority, therefore they shall be junior to the junior most in past services under Regulation 3F shall, however, count toward leaves, pay, and increment. Nowhere this the letter of 2007, Your Lordship, speak about pensionary benefits, Your Lordship. Past services under Regulation 3F shall, however, count toward leave, pay, and increment as per existing provision. Nowhere, Your Lordship, this letter of 2007 speak about pension, Your Lordship. So, in my humble and respectful submission, Your Lordship, the finding of the learned single judge, Your Lordship, is erroneous, Your Lordship.
Where is that letter of 27th August 2007?
Lordship, that letter is not there, but this is the this has been reproduced, Your Lordship, in this letter dated 19/2/21, Your Lordship.
What has been recorded by the learned single judge is something different.
Lordship, yes, Your Lordship.
No, but then we would like to see that.
Then, Lordship, I'll have to get that letter, Your Lordship.
Mr. Kanta, you have this letter?
The letter of 2007, Your Lordship.
I don't have.
It is at page 242 of the writ appeal.
242.
Yes.
And this letter has been marked to the finance department also.
Oh, I'm sorry, Your Lordship.
Marks to the finance department at serial number 10.
Yes, Mr. Shulai.
Lordship,
you read that page 244 at the last para 2.
Would be taken into consideration for the purpose of leave, pay, pension. Would be taken into consideration for the purpose of leave, pay, increment, pension, etc. as per existing provision under. But Lordship, the 1921 letter, Your Lordship, at page 77, Your Lordship.
It could have been an inadvertent. You see,
it cannot be, Your Lordship.
Otherwise, why would they have referred to this letter? Why would they leave out this portion?
Lordship, because the condition is stipulated in the letter 19/2, Your Lordship, where the pension is not included, Your Lordship.
But reference was made to this 27 to
this. It's true, Your Lordship. August. It is true that a reference has been made to the letter dated 27/8/2007, Your Lordship. But in the letter which has been issued, that is on 19/2/21, Your Lordship, that
Are you trying to give an interpretation that 2019 letter is an improvement upon this 2007 letter? It is not in use in supersession. It's only a reflection of what is the content. And now what we find that this pension part has been missed out there, and that is why it is entire wrong. Thereafter also, you would like to press this appeal.
I'll leave it.
Please take instruction and then.
Lordship, I'll have instruction, Your Lordship. Then.
Please, you do, see,
Lordship,
unnecessary. Totally, it
I'll have
seems as
instruction,
only
Your
on the
Lordship.
basis of Richard. Because
Lordship,
of,
yes.
see, 2019 basically reflects that
2021.
2021 only merely reflects that.
Lordship, yes. I'll have instruction, Your
That's
Lordship.
why I said.
Why?
See,
What?
it could have been an inadvertence.
Lordship,
somewhere.
why that word pension has been omitted in the letter of 19 to 2021?
There is no clarification, and that point has not been urged before the trial court. You come back.
Lordship.
There is nothing. What is the use of pursuing it?
Lordship, next date, next date, Your Lordship, if clarification is given to, I would fairly submit, Your Lordship. I might withdraw also, Your Lordship.
That is what should be done.
Lordship, I'd like to request a shorter date.
Next week.
Yes, Lordship. Much obliged.
Mr. Shah?
Next week, Your Lordship.
That will be 19.
Yes, Your Lordship. Just to take
Up to you,
instruction.
Mr. Shulai.
Just to take instruction. There's nothing.
If it comes on 24, Your Lordship. 24.
No, this court sits only on Wednesday.
Wednesday. Then Lordship will kindly excuse me. Then let it come on 26.
Have it.
Apply it.
Heard Mr. Indishra, Learned AG. The hearing.
My colleague says the
hearing is yet to be concluded. As prayed for, the hearing will continue on the next date fix. On by consent of the parties, list is met on 26.
On 26, Your Lordship. Highly obliged, Your Lordship.
Item number 5.
Lordship, this requires a preparation of the paper book, Lordship. We're still under process, Lordship. 1 week will do it. I'm praying for 1 week time, Lordship.
Mr. Melompier, counsel for the appellant, has sought for some more time to file the paper book. On premium, seems long, place is matter after 1 week.
Apply, Your Lordship.
Item number 6.
this case, Mr. Chakravarti appears, my lord. I have been just requested, my lord, that he will be coming. If it can be taken up in the end of the board, I don't know, my lord, subject to your lordship convenience.
My lord, I am seeking some more time. I have to go through the record of the trial court, my lord. Partly I have done, my lord. It's a voluminous, my lord, record.
In other
As
words,
per the last,
you are not prepared.
my lord, we were instructed to go through both the counsels were.
Who has instructed you? You see, you are the master of your case, of your brief. You have to. It's incumbent upon you to go through it. The matter is, it was partly heard.
My lord, yes.
What happened is, so next time around we may forget what has been submitted.
At the time of the hearing, my lord, it came out certain queries were there from the.
That is only on that.
Yes.
I think my brother has raised
Yes,
that
yes.
issue. Certain technical.
My lord. My lord, yes.
On premier with the appellant, list this matter after 1 week.
Reply, please.
Okay.
Item number 13.
My lord, this is the review application, my lords. In fact, it was finally heard, and it was pending, I think, more than now, my lord, 7 months. So, my lord, situation will demand a fresh hearing. So far I am concerned, my lord, I am ready. I filed a written argument.
My lord,
if your lordship take it up,
even we have filed, my lord.
My lord, if your lordship take it up today, my lord, I am ready.
You have to refresh the code.
I am ready even today, my lord, but subject to the convenience of the court.
My lord, let it come after 2 weeks. My lord.
My lord, 2 weeks is too long time. The matter has been pending for too long, your lordships.
My lord, the matter
and
was
I know
in
this
fact
matter will
finally-
be delayed, adjournments.
My lord, No, he cannot. My lord,
Let it come
our
up, my lord,
argument
next
part
week.
we have argued, my lord. We have argued, we have filed written argument.
It requires a fresh argument. That's what I am saying. More than 6 months it requires.
I have forgotten whatever.
Yes.
So, my lord, let it come after, my lord, my prayer.
No, we'll take it up
Tomorrow?
next week. We sit only on Wednesday.
Only Wednesday.
My lord,
Let it be. My only submission, my lord, whatever your lordships, I am ready, my lord. Next Wednesday, let it be taken up next Wednesday.
My humble request, my lord, if it is kindly taken up on 26th, my lord.
Well, what is the problem, my lord, next Wednesday?
You see, you
I
have
have
to
some
you have
difficulties,
to
my
understand this. You see, any case that is taken up with the court, you see, time factor is irrelevant.
My lord.
One way or the other, we have to dispose.
Yes.
In fact, the more it's delayed, the more it weighs heavily on the court as well as on the parties. So it is for all I think it would be beneficial for all concerned to get the matter.
But, only difficulty, my lord, I have some personal difficulties. That's why, my lord, I was praying if it is taken up on the 26th.
Then definitely.
Yes, but only thing, my lord, personal difficulties I cannot object your lordship. Only lordship will ensure, my lord, on 26th is taken
That's
up.
what I said.
Yes, 26th.
On premier by the on accommodation sought for by Mr. K.P. Vershadi, Learned Counsel for the State Respondent. This will not be objected to by Mr. S.N. Learned Counsel for the Review Petitioner. Matters adjourned. List the same on 26 as the first item in the hearing list.
My lord.
All right.
Item number 14.